Hello and welcome, and thank you for joining us. I'm Greg Rees, President and CEO of AmeriEstate Legal Plan, and today we're going to talk about the differences between revocable and irrevocable trust. As of late, we are getting a lot of calls from new customers that are specifically not just asking about irrevocable trust, but requesting irrevocable trusts. And so that begins a process of really trying to understand what the goals are that they have in mind to determine whether or not an irrevocable trust would be better suited to their situation than would, say, a revocable living trust. So today we want to use this opportunity to kind of, talk about the differences between the two, really as a highlight. Specific circumstances will be different for every family and every person, but today we can get a better understanding of what are the differences between a revocable and an irrevocable trust. So let's dig right in. So a key feature of revocable trusts is that they can be altered or changed at any time, allowing the grantor or the creator of the trust to make changes as their circumstances evolve. So it allows them to make changes to beneficiaries, make changes to the order of trustees, things of that nature. And another important benefit of revocable living trusts is that they avoid the probate process at the time of death. So taking the courts and the attorneys usually out of the equation, saving the estate time and money. An important benefit of revocable trusts is they ensure that property and assets remain readily available for you, even if you become incapacitated. So they're not frozen. So incapacity can sometimes lead to a situation known as conservatorship. Conservatorship is where you're still alive, but now the courts have to kind of step in and take control because you don't have legal capacity to make decisions over your business affairs and personal affairs, and the courts need to step in. And that's time-consuming and expensive as well. So key benefits of revocable trust. Some of the key advantages, mentioned one of these before, but flexibility and control. Grantor can modify the trust at any time. It does avoid the probate process. Assets held in a revocable trust can bypass probate. We're going to talk a little bit more about that one in a minute. Number 3, in the event of the grantor's incapacity, which I just touched on, a successor trustee, somebody appointed by you to step in for you. Consider yourself the president, and you're appointing your own vice president so that if something happens to you, that next person, we call that a successor trustee, can step in and seamlessly manage your affairs and take care of your business, and make sure that your income is coming in, your bills are paid, etc. So, and again, that can happen without the intervention of the courts. Drawbacks, there's always pros and cons to everything. So, number 1, assets within a revocable trust remain subject to creditors and legal claims against the grantor. Revocable trusts do not provide asset protection. That is not their primary function. Number 2, the trust assets are still considered part of the grantor's estate for tax purposes, meaning that when you pass away, depending on the size of your total estate, all assets in your revocable trust are part of your taxable estate. So if you hit the threshold, and they're pretty high, so most people are not affected by that. Number 3, retitling of assets can be time-consuming, but necessary to fund a trust. Not all assets will be retitled. So think of it this way. For a trust to really be effective, so that it controls the continuity of management, so that it avoids the probate process, the assets that you own need to be retitled into the name of the trust. Taking a bank account or title of my property, for example, from my individual name or that of myself and my spouse to myself and my spouse as trustees of, we'll call it the Rees Family Trust in my case, right? So the Rees Family Trust is the owner, and the names attached to that titling are an indication of who is in control of the trust, the trustees. So Greg Rees and my wife would be named as part of that titling. Now, think of a trust more or less like a safe. You got all your valuables, your home, your assets, your investments, and things of that nature, and you want to buy a really nice safe to put all those assets in for protection, right? Well, the analogy here is when you bring that safe home, you've got to put all of your assets inside that safe. You can't just leave the safe door open and stack everything on top of the safe. It's not protected. They need to be inside. So, you need to retitle assets with the bank do deeds to retitle property, etc. And as I mentioned, some assets do not get retitled to the trust, and that's a very small subset. So typically things that already have, by definition, a beneficiary designation generally don't go into a trust. Things like your IRAs and 401k plans don't get retitled to your trust. You have a separate specified beneficiary designation attached to that account. You can name your trust as a beneficiary or as a backup beneficiary, but the titling itself doesn't change. Other things might be life insurance, could go either way, but they have dedicated beneficiary designations. Annuities, same situation. So there's really a relatively small subset of asset classes that would not get retitled to the trust, but largely almost everything else should be. All right. So let's talk a little bit about irrevocable trusts. Irrevocable trusts are permanent and have specific tax advantages, but come with a loss of control for the grantor. Once established, an irrevocable trust generally cannot be modified or revoked without either the consent of the beneficiaries or consent of a court on compelling circumstances. So think about that. Irrevocable trusts cannot be changed once they're established. And the general idea of creating an irrevocable trust is that either you're going to lose some control or you're going to lose access to your assets, or maybe both. And so when we dig into people that say, hey, I really want an irrevocable trust, we first need to make sure they understand that, well, in doing so, there may be valid reasons for it. And there are certainly circumstances where they do make a lot of sense. But you're generally going to be losing control or some access to your assets. So that's a key component of the decision-making process. All right. Benefits of irrevocable trusts. Number one, asset protection. Generally speaking, assets placed into an irrevocable trust are shielded from creditors and legal claims, providing enhanced protection for you. Number two, estate tax planning. Irrevocable trusts may help reduce estate taxes as the assets are typically excluded from your taxable estate when you pass away. Number three, gift tax benefits. Irrevocable trusts can facilitate the gifting of assets, potentially minimizing gift or estate taxes. Okay, so it could be a mechanism by shifting part of your estate to the next generation, shall we say. What are the downsides of irrevocable trust? Well, I mentioned the first one. Oftentimes, it involves either losing some or all control or losing access to your assets themselves. But once assets are transferred to an irrevocable trust, the grantor relinquishes control, as I just said. Changes, again, may require the consent of the beneficiary or may require court approval. So think of the differences. Revocable trust is what most of us will have as really the foundation of our estate planning, because it allows us during our lifetime to make changes along the way as our lives change, as circumstances of our family change, as new assets come in or go out of our estate. We can make those changes in a revocable trust. Where an irrevocable trust, you've got to contemplate that whatever decisions I make today are permanent, right? So, another potential downside of irrevocable trusts is, the creation and administration of these types of trusts can be more complex, requiring more legal expertise and maybe more frequent involvement with your attorneys to make sure that things are being managed properly. Number three, irrevocable trusts often have more complex language and terms. So, they may have terms and language in there that may be hard to understand. And again, you may have to have more interaction maybe with your legal counsel in order to understand exactly what the rules and responsibilities are in managing an irrevocable trust. Okay, so pretty short and sweet, but today I don't really have time for questions. But if you have any questions or thoughts, you can give us a call. Here's our number, 800-235-0963, or you can email our office for further discussion about your specific circumstances. But again, thank you for joining us today to learn the differences between revocable and irrevocable trusts. Bye for now.